observed whether the public participation was sufficient to meet the test is a question of fact. We agree that the Constitution must be interpreted holistically as was held in CCK and others versus Royal Media Services and others. Under Section 36(2) of the Community Land Act, an agreement relating to investment in community land can be made between the investor and the community. Section 36(3) provides that no agreement between an investor and the community shall be valid unless it is approved by 2/3 of adult members of a community assembly meeting called to consider the offer and at which a quorum of 2/3 is met. This requirement is replicated in Rule 22 of the Community Land Act Regulation 2017. The first respondent has stated that Cherab Conservancy is one of its 43-member conservancies, which is fully operational and has commenced the construction of rangers, outposts, and headquarters offices, which will serve and benefit the members of the marginalized communities. Further, the first respondent has averred that there was adequate and extensive public participation on this project with the members of the community before the commencement of the project, including the preparation of the EIA assessment report or study by followed by a NEMA license as per Annexure TL1 and 2 and 4. On their part, the second and seventh respondents through their deponents did not address the question of public participation, let alone its effectiveness, modalities, timelines, particulars, participants, and or reports before, during, and after the first, third, and sixth respondents started and operationalized the setting up and commissioned the establishment of community conservancies in Isiolo County in general, and in particular in Cherab and Chari wards in the year 2020 up to the filing of this petition. The only issue that the second respondent commended was a public participation during the presentation of the County Assembly Bill. The petition was filed on 4th of October 2021. Filed its replying affidavit in response to the petitioner's further supporting affidavit, the first respondent adduced TL1, which is a certificate of registration for Cherab Conservancy, which indicates its date of registration as 28th of May 2021. TL2 was the community awareness documentation setting out details of alleged meetings, which is dated the 5th of January 2023. TL3 was an EIA report for the proposed Cherab Conservancy. The report that was supplied to the court was, however, not signed and dated. TL4 or Annexure TL4 is the NEMA license, which was issued on 18th of November 2022 for the construction of Cherab Community Conservancy Headquarters. Under Section 31(1)(e) of the Wildlife Management and Conservation Act, the Cabinet Secretary, in consultation with the competent authority, is required to gazette areas zoned to have a wildlife conservation and management as their land use priority. The section further provides that such an area cannot be gazetted until the relevant provisions of the Environment Management and Coordination Act have been complied with and public participation has occurred. Section 58(1) and 2 of the MCA requires that any person being a proponent of a project shall, before financing, commencing, proceeding with carrying out, execution, or conducting any undertaking specified in the second schedule to the Act, to submit a project report to the authority and also undertake a full environment impact assessment and a study report. The evidence by the first respondent through the aforementioned annexures were all prepared after the petition was filed, but more importantly, the documents do not address the issue of creation of conservancies in the sued lands as required under the Wildlife Management and Conservation Act and the Environmental Management and Coordination Act. Equally, there is no evidence standard that the second and eighth respondents facilitated public participation relating to the nature, extent, benefits, and impacts of the establishment and running of wildlife community conservancies in unregistered community lands in Cherab and Chari wards. There are no records that were undertaken by the state agencies showing meetings, press conferences, gazettement, briefing of members of the public via barazas, and structured questionnaires concerning wildlife community conservancies in community land before October 2021 when the petition was filed. Additionally, there has been no disclosure of any approvals from the relevant bodies authorizing the first respondent to establish a conservancy. There is no evidence of an environmental impact assessment, environmental social economic impact assessment, economic social impact assessment, or any feasibility study conducted prior to the establishment of the conservancy, despite the fact that the same is bound to interfere with the community's ability to continue with their social and economic life as pastoralists. It is therefore the finding of the court that the first, second, seventh, and eighth respondents breached the principles of public participation, which is a constitutional imperative under Articles 10 and 69, 1, D, E, and F of the Constitution. The petitioners have further complained that the first respondent, working as an umbrella group, together with the third to sixth respondents, established and is running community wildlife conservancies in unregistered community land within Isiolo County without express consent, approval, authority, or mandate from them and the community at large. In response, it was asserted that the first respondent is a non-profit members organization and that the rights of the petitioners to the land rang equally with those of the third to sixth respondents and indeed other community members who wish to adopt conservancies as a legitimate land use for the collective benefit of the community. Additionally, it was debunked that petitioners do not have veto power over decisions made by other members of the community, and neither can they dictate how the sued land can or should be managed or utilized. Our reading of the Wildlife Conservation and Management Act is that it has not adopted a fixed model of what a wildlife or community conservancy is, so long as it adheres to the underlying legislative principles, concepts, and governance standards. The Wildlife Conservation and Management Act, in our view, leave no room for the first, third to sixth respondents not to comply with the law on membership, running, registration, constitution, regulation, governance structure, authorized activities, and compliance with the Constitution as regards sustainable development, public participation, and the right to fair administrative action. Section 39 allows any person to establish a wildlife conservancy. Section 87B provides that KWS shall maintain registers of national parks, national reserves, wildlife conservancies, and sanctuaries managed and established under the Act. The first, third, and sixth respondents based their response on annexed titled A Guide to Established Community Conservancies NRT Model, which is dated January 2015. The version whose authors are Juliet King, Tom Lalamba, Ian Craig, and Mike Harrison. The same is not a government policy. It has no legal force beyond the operations of the first respondent. It cannot override the Constitution and the statutes. A member of a team may not unilaterally set the regulations of the game and impose them on all the players. The manner in which the first respondents model was produced has not been explained. Whether it was subjected to public participation and approved by the relevant ministry has not been indicated. The first, third to sixth respondents cannot be both a team player and a regulator of the manner of establishing and running conservancies on their terms in total breach, ignorance, and overlooking of the Constitution and sectoral laws governing the establishment and running of community wildlife conservancies. From the statutory framework, it is evident that the community conservancy must seek registration from the Community Wildlife Conservation Committee after filing the required application form and depositing key documents, among them the land size and land agreement and management plan. That is as per Schedule 8 of the Wildlife Conservation and Management Act. The third to sixth respondents have not sworn an affidavit attaching their aforesaid licenses, permits, legal registration status, and the approvals that they have been authorized to establish and run community conservancies under the umbrella of the first respondent in Cherab and Chari wards. We are in agreement with the petitioners that the first, third, and sixth respondents are acting or undertaking their activities relating to community conservancies outside the constitutional and the legal framework set out above, and hence have infringed, threatened, or violated their rights to property. The first respondent averred that it applied its model in the establishment of the imbued conservancies, and that donor funds have been sourced for the project, and tenders opened for the same. Otherwise, to stall the exercise through court orders will prejudice it and the community in general, and will impede their freedom of association under Article 36 of the Constitution of Kenya, and will also improperly limit and restrict the community's right to access, use, and benefit from their property, contrary to Articles 10, 42, 40, 43, 50, and 69 of the Constitution, and will violate Kenya's commitment under the CBD 1992. However, the Constitution, the Wildlife Management and Conservation Act, and the Community Land Act provide for the involvement and participation of all members of the community in the conservation and management of natural resources, including conservancies. Therefore, to the extent that the respondents have not complied with the said laws, it is our view that the petitioners' rights in respect to the unregistered community land have been infringed. The petitioners contend that in the operations of the conservancies, the first respondent has taken extreme measures, including arming rangers whose presence in the county elicits tension, that there have been several instances of violence, loss of life, and forceful disappearances, as was the case in the establishment of Piligo Pulesa Conservancy, and that the first respondent uses the armed rangers as a private army for quelling any opposition by the community, and that as a consequence, there has been a rise in the proliferation of small arms in the region as the members of the community try to defend themselves. In response, the first respondent contends that its armed rangers operate as wildlife scouts and hold the status of police reservists. They deny any allegation of violence instigated by their rangers. Article 239 of the Constitution defines Kenya's national security organs as the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. The primary objective of these organs is to promote and guarantee national security in accordance with the principles outlined in Article 238(2) thereof. These principles emphasize the compliance and respect for the rule of law, democracy, human rights, and fundamental freedoms. Article 238(2)(c) provides that in performing their functions and exercising their powers, national security organs shall respect the diverse culture of the communities within Kenya. Article 243 further establishes the National Police Service, comprising of the Kenya Police Service and the Administration Police Service. The functions and objectives of the National Police Service are elaborated in Article 244, which include maintaining public safety, upholding the rule of law, and respecting human rights. Further, the National Police Service Act sets out the establishment of National Police Reservists. This section establishes National Police Reserve, which is composed of individuals who are citizens of Kenya aged between 18 and 55 years. and volunteer for service and are enrolled as reserve police officers. Section 110(3)(a) of the Act further stipulates that police reserve officers must be provided with proper uniforms, service identity cards, and weapons, and be deployed in specific areas with defined commands and supervision structures, and undergo vetting and training before deployment. Section 110(4) thereof provides that reserve police officers are subject to the same requirements as regular police officers and must be supervised by the National Police Service. Additionally, Section 110(5), the Commission is obligated to maintain an updated database of all reserve police officers. Finally, under Section 111, evidence of appointment of a reserve officer shall be the certificate of appointment which shall be issued to every reserve police officer upon appointment. Section 87 of the Wildlife Conservation and Management Act imposes additional regulatory obligations regarding the management of firearms and the personnel involved in wildlife conservation, mandating the seventh respondent to maintain a register thereof. Despite the first respondent's assertions, it has not provided any evidence to demonstrate compliance with the above statutory requirements. No certificate of appointment have been provided evidencing appointment of the rangers. Neither have they been shown to be properly registered, vetted, trained, or supervised in accordance with the National Police Service Act. This is aggravated by the second and seventh respondents' admission of the non-existence of any registers for the armed rangers. In a region characterized by the proliferation of firearms, the regulation and oversight of armed personnel are critical to ensuring public safety and adherence to the rule of law. The lack of transparency and accountability regarding the armed rangers undermines these objectives and raises serious concerns about the legality of their operations. In light of the constitutional and statutory frameworks governing national security and law enforcement, it is evident that the existence and operations of the first respondents armed rangers are unconstitutional and contrary to statute. The first respondent's failure to provide evidence of compliance with the National Police Service Act and the Wildlife Conservation and Management Act further reinforces this conclusion. These rangers cannot lawfully exercise functions that are reserved for duly constituted national security organs without adhering to the prescribed legal framework.
Out of those efforts, the National Land Commission gave an advisory dated 14th of June 2021, noting that the first respondent had been suspended until the community was sensitized and approved the first to sixth respondents' initiatives. Equally, the ninth respondent, by a letter dated 31st of May 2021, acknowledged receipt of the complaints by a section of NRT residents of non-inclusion in the community engagement of the proposed conservancy. In a letter dated 9th of May 2021, the ninth respondent directed the first respondent to hold the establishment of the conservancy until there was inclusive, participatory, and wide consultations with the local community. All these attempts were ignored by the first respondent. Equally, the second, seventh, 8th, and 9th respondents before this court did not say whether they enforced the resolutions alluded to in Annexures A03, 4, 5, and 6. In view of the foregoing, this court must therefore issue orders that not only remedy the violations, but also reinforce constitutional accountability and discourage any future disregard of participatory and lawful processes. We now summarize our findings and conclusions on the issues framed for determination as follows. 1, It's our finding that the petitioners have the requisite local standard to institute this petition on their behalf and on behalf of members of NRT sub-county, Chari and Cherab wards in Isiolo County. 2, we find that the petition before the court was pleaded with sufficient precision, setting out the nature of petitioners' alleged violations and meets the constitutional threshold set out in the Anarita Karimi case. 3, we find that the petitioners did not, in instituting this petition, breach the doctrine of remedies. 4, we find that the petition raised justiciable issues, controversies, and significant questions of fact and law, whose resolution lies within the ambit of the Constitution rather than statutes. 5, we find that the 2nd and 8th respondents have breached their constitutional and statutory mandates by facilitating, or rather by failing to facilitate, the registration of the unregistered community land in Chari and Cherab wards, NRT sub-county in Isiolo. 6, it's our finding that the establishment of the conservancies in the unregistered community land in Chari and Cherab wards has been undertaken in breach of the constitutional principles of public participation as enshrined in Articles 10 and 69, 1, D, E, and F of the Constitution. 7, we find that the 1st, 3rd, 4th, 5th, and 6th respondents are conducting activities relating to community conservancies outside the constitutional and legal frameworks and have, as a result, infringed and violated the petitioner's constitutional rights, including but not limited to property rights. 8, we find that the existence and operation of armed rangers in the conservancies in Chari and Cherab wards under the management of the 1st respondent are illegal and unconstitutional. Ultimately, the court finds that the petition is merited and proceeds to issue the following orders. 1, a declaration does hereby issue that the establishment of conservancies in Chari and Cherab wards, NRT sub-county, was undertaken without due public participation and is consequently unconstitutional. 2, a declaration does hereby issue that Cherab Community Conservancy, operated and chaired by the 3rd respondent, and Bulesa Biliko Community Conservancy, operated by the 4th, 5th, and 6th respondents, are operating illegally insofar as establishing and purporting to establish conservancies in Chari and Cherab wards, NRT sub-county goes. 3, a permanent injunction does hereby issue prohibiting and forbidding the respondents, jointly and severally, whether acting by themselves, their agents, servants, representatives, assignees, and or umbrella bodies of the 1st respondent, from entering, mapping, surveying, and delineating, carrying out conservatory operations, including the recruitment, employment, or entering into any other forms of contracts, evicting community members, carrying out any activities, or in any way disposing the unregistered community land in Chari and Cherab wards, NRT sub-county. 4, a permanent injunction is hereby issued prohibiting the 1st, 3rd, 4th, 5th, and 6th respondents, jointly and severally, whether acting by themselves or anyone under them, from operating or deploying rangers or guards to operate in any part of Chari and Cherab ward, NRT sub-county. 5, an order is hereby issued directing the 2nd respondent to coordinate with the 8th respondent and the petitioners and offer necessary facilitation on the registration of the community land in Chari and Cherab ward, NRT sub-county, under the Community Land Act. 6, an order does hereby issue directing the 7th respondent to revoke any and all licenses and authorities that may have been granted to the first, third, fourth, and fifth, and sixth respondents related to the establishment and management of community conservancies within Cherab and Chari wards, Mete sub-county. 7, an order does hereby issue compelling the 9th respondent and the Isiolo County Police Commandant to oversee the implementation of the orders sought herein and to ensure that peace and order is maintained. 8, the court declines to grant any damages. 9, costs are awarded to the petitioners to be borne by the respondents jointly and severally. This judgment is dated this 24th day of January 2025, signed by the 3 of us, and we thank the advocate.
Wanyonge wamepata haki zao na majaji watatu ambayo wamekalia ile shida ambayo ilitokea kwa mambo ya conservancy, haswa baina wananchi na NRT. Ingawa hiyo mambo imeendelea kwa muda mrefu, ingawa wanyonge wamelalamika kwa muda mrefu, leo haki imepatikana na hawa majaji watatu walitoa hukumu ya haki. Tunatoa shukrani kwa National Human Rights Commission ambaye headquarters zao ya Northern Kenya, ambaye headquarters yao ni Wajia. Lawyer Adan Dalacha ametusaidia. Asante pia kwa lawyer yetu kijana mzaliwa hapa anaitwa Abdullahi Halkano Kela na malawyers yote ambaye walitusaidia kupambana na dhulma. Sisi kama wafugaji, ardhi ndio rasilimali ya kipekee ambaye tuko naye sisi. Na ikiwa sisi hatuwezi kulinda, haswa wakati huu kuna community land registration inaendelea, alafu wengine wanataka kupora kutumia kwa njia isiyofaa, basi sisi tutaumia zaidi. Kwa hivyo ndio tumeungana sisi wana harakati wa haki ya kibinadamu wa media wetu wa kinyumbani kama Angaf Radio na sehemu zingine. Tumeshughulika sana kuona ya kwamba haki ya umma imepatikana. Hiyo ni sio kusema ya kwamba sisi tunakataa donors ama investors katika ardhi zetu, lakini tumesema NRT wakaa kando kidogo mpaka tupate land registration ambayo katiba sasa imetupa.
Ruling, and our clients and myself are quite happy and welcome that judgment. We think that judgment is quite extensive and it's very, very well reasoned, and it has offered a lot of guidance and structure on this issue that concern the establishment of conservancies and the issue that's concerning community land rights. I believe for our clients, this has we are welcoming it, and it has very far-reaching ramification in terms of affirming their rights as community members and as members who own the property. They are the ones who should be consulted first, and the court has established a structure of what is supposed to happen if indeed you want to engage the community or you want to utilize the community in any way. Yes, indeed. Before we came, we filed this case in 2021, and it's been quite a journey before we got here. And before a judgment is rendered in a case, according to our constitution, the court usually gives parties an opportunity to speak and try to negotiate and try to solve these issues before, the court can give its judgment. So prior to coming to court, we try to engage officials, and as you've heard from what the judge has said, we try to engage the local authorities, we try to engage the ombudsman, we tried to engage the National Land Commission. So we tried so much. We did not just wake up and go to court, and that's why even the court ordered and made a finding that indeed we tried alternative dispute resolutions before coming to court. So coming to court was our last resort. I think I was very, very confident, and what made us confident in this case is the extensive research that we did prior to filing this case. And we thought that there are glaring, constitutional issues surrounding these, issues that brought us to court. And we perused the Constitution and the Community Land Act and noticed that there are so many, violations that the court has just affirmed and agreed with us. So at this point, it's no longer an allegation, but it's a factual finding of court that indeed the members of Merti County, Merti Sub-County, were not involved when these conservancies were established. The court has made a finding that there was no public participation. And the court has also made a finding that these conservancies that are operating in these areas are doing so illegally. And the court has also made a finding that even the rangers and arming of rangers is not according to the law.
Insofar as the judgment has been delivered, a lot of effort has gone into it. In terms of the orders, we think that that decision for those who have been in this conservancy movement for a long time, that decision is extremely dangerous, if I may use those terms. And I say, why do I say that? Our main arguments in law and fact were that a conservancy is basically a unit of development right at the community level. It gives the community opportunity to come together, to mobilize, to use their land for development projects. Now, this case concerned two conservancies. In Isiolo, there were disputes around public participation. The allegations were that NRT, the communities, did not engage in a process of public participation that meets the legal requirements. We put in our responses. Unfortunately, the court did not agree with us. We have sought leave so the judgment to be stayed because we think that there are areas where the judges, with utmost respect to them, misdirected themselves. They have failed to appreciate the law. In a matter of environment of this nature, one should be very, very careful, we respectfully submit, about the orders they make and the implications those orders will have. Now, from the conservancy movement, we made it very clear when we were highlighting our submissions that the conservancy movement preceded the 2010 Constitution. There were conservancies established before that. So that these issues that the petitioners, we say, weaponized to try and kill these two conservancies came even after some of the conservancies were existing. The other thing that we think the judges, again with respect, failed to appreciate is the role of KWS vis-a-vis